right, I think we should get started. So hello, everyone. Welcome to this session. My name is Herman Chique Alfonso, and I'm the Education Coordinator for the Dementia Society of Ottawa and Brantford County. It's a pleasure to be here today as your host. So we have a very special, interesting session today, and it's about legal aspects for caregivers and how to navigate workplace concern as a caregiver as well. And we have a special guest today, Raphaëlle Laframboise-Carignan, and welcome, Raphaëlle, to the Dementia Society of Ottawa and Brantford County.
Thank you so much. I'm very pleased to be here and to be speaking with your group and hopefully share some information that will be helpful to you as caregivers. The focus of today's presentation is issues or concerns in the workplace and the impact on a caregiver's ability to remain in the workplace and ability to work. Now, the information that I'll be sharing today is really more focused on your duties and responsibilities as a caregiver and the impact in your workplace. However, the information that I'm sharing may also be pertinent or helpful to people living with dementia, depending on the stage and progress and whether or not they're still at work. The information that I'm providing today is just legal information. It is not legal advice. And if there are any specific concerns, my recommendation is always to consult with a lawyer who is specialized in labor and employment. Now, before I get started, a little bit about myself. I am a lawyer and partner at RavenLaw. We are a labor and employment law firm where we represent employees and unions on all aspects or issues relating to the workplace. And we have offices across Canada in Winnipeg, Ottawa, Kingston, and Toronto. So to get started, the first area that I would like to cover and present to you is this legal concept of duty to accommodate. Now, my focus will be on Ontario and the federal sector, which is specifically relevant in Ottawa, just given how many of us work in the federal sphere. So both Ontario and federal human rights law have recognized the need for employees to be able to work in an environment that is free from discrimination, okay? And what that means is that an employer has an obligation to do what they can to ensure fairness for all employees and to treat their employees fairly, okay? They've come up with the concept of a duty to accommodate. And this relates to grounds that are protected under both Ontario and federal human rights laws. And those grounds vary, but the ones that I will be focusing on today are family status, marital status, and disability, as I believe those are the grounds, the protected grounds under the Act that most likely apply in circumstances for caregivers. And so to make things fair for employees, employers have positive obligations to make changes in a workplace to remove certain barriers. Now, accommodations can be sort of a redesign or an adaptation of one's personal responsibilities at work or the work environment generally. Now, accommodations can come into play in a variety of settings. One can be when an employee is still at work, but is finding that because of their medical conditions, which may be linked to, various aspects, but may be linked to their caregiver duties or their caregiver duties, that they're having trouble at work, but want to remain and are able to remain at work. And so there may be a need to accommodate. Or in other circumstances where an employee has left the workplace and is looking to come back and needs accommodations to ensure a successful return to work. Now, For today's discussion, like I said, my focus will be on 3 protected grounds under both provincial and federal acts. Disability being one of them. And so this means, and it's a very broad definition, but it means any degree of physical disability, illness, injury, any degree of mental impairment, developmental disability, learning disability, mental disorder, okay? When it comes to family status, the ground that is protected under the Human Rights Act defines it as the relationship between a parent and child, or something that is equivalent to that type of relationship. Marital status would also operate here in the same sense as family status, but with respect to a spouse or partner. Okay, and I'll be analyzing or providing information on these 3 grounds when it comes to accommodation. Now, accommodation is very specific to an individual and an employee, and their needs will differ from that of another employee. Okay, and so when an employee is faced with either being at work or looking at returning to work and finding that they are having trouble completing their duties or difficulty sort of meeting their targets, and that the reason for that is linked to one of those grounds that we mentioned. So either someone is experiencing burnout symptoms because of their obligations, their caregiver responsibilities, or for an unrelated matter, but are finding that they have physical or mental symptoms that are affecting their ability to work, or if they're finding that their caregiver responsibilities, in terms of maybe bringing someone to appointments or checking in on an elderly parent, are impacting their ability to work like they used to, then that's when an employee should start questioning whether or not they can remain at work, but would need accommodation to help them do so and to be successful at work. And so if an employee believes that they would need accommodation to sort of remove any barriers, then they should question and start asking questions and communicating with their employer with respect to this need for accommodation. Now, when it comes to accommodation, the biggest rule is communication. It is on the employee to start communicating with their employer about what needs they need, okay, or have. So the first thing to do that I would recommend is, if you're finding yourself to be in this position, is to start communicating, ideally in writing, with your employer about what is happening, right? And so what's happening in your life, what are the needs, and what are the difficulties that you're facing? The employer is entitled to have the information that's necessary to be able to analyze an accommodation request. Now, when it comes to a disability accommodation request, the information has to be enough for the employer to understand what the employee's limitations and restrictions are in terms of their ability to work. Now, that doesn't mean that the employee has an obligation to provide a diagnosis. To the contrary, there is no obligation to give a diagnosis, but the employee does need to provide enough information so that the employer can properly assess the request and see what changes can be done in the workplace to accommodate. In terms of family status and marital status, and the reason that I bring both up is really the family status, as I mentioned, is recognized mostly in the sense of a parent-child relationship, whereas marital status is between spouses, partners. So in those instances, if there is an accommodation that is being requested, it's slightly different in terms of what needs to be communicated to the employer to start engaging in those conversations. In those cases, what the law or the case law suggests is that the employee has an extra step that they have to take. They have to be able to look at other possible options. Have they considered whether a friend or other family member can do specific caregiver duties? Have they looked at engaging the services of a personal support worker, or a lot of these cases come up in the context of children, so a babysitter. Is it possible to move the relative that needs the assistance closer to the employee's residence or workplace? And so there's this extra requirement on the employee when it comes to requests for accommodation in the family status, marital status, caregiver responsibility sphere, to explain to the employer what steps have been considered and looked at, maybe tried, and it didn't work. And this goes so far as really giving information about, who has been contacted, what are the actual costs involved in these additional steps, and explaining why those are not viable options in these circumstances. In terms of the employee responsibility for starting and engaging in an accommodation request, it really comes down to providing the information about what is needed, what and why it is needed, and the impact of on the workplace or on your ability to work. Okay. Once that information has been communicated, and ideally in writing to the employer then has an obligation to analyze an employee's request, to look at the particular needs of that individual and that employee, and analyze what can be done to meet that individual's specific needs and the needs of the workplace. Okay. It's important to know that a request for accommodation doesn't necessarily mean that the employer has to accommodate you the way that you are asking to be accommodated. As an employee, we have an obligation to provide information about our limitation, restrictions, or needs, and then it's on the employer to see what is viable and possible within their workplace. Now, if they can accommodate you in a different way, but that still meets your needs and limitations and restrictions, but is not done in the specific way that you would like, that doesn't mean that they have failed in their obligations. It doesn't need to be exactly what the employee is asking for, as long as it meets their needs. Now, in terms of examples of accommodation that can be requested or discussed with the employer, there's really quite a wide variety. And because they're specific to the employee, some apply to some employees and others don't. But just to give an example, in terms of accommodations for a disability, those would look like ergonomic assessments, reduced work hours, reduced or different responsibilities, bundling duties, modifying targets, right, or standards, allowing for more time off for appointments or consultations, providing different tools to do the work, providing different furniture or equipment, allowing telework, allowing more time to work from home. So those are some of the types of changes that could be done to accommodate one's disability. In terms of family status or marital status in the context of caregiving, that could also look like reduced work hours, flexible work hours, compressed work weeks, job sharing, allowing for longer or more leaves of absence, flexibility in terms of using sick or vacation days, reducing responsibilities, allowing from working from home. And so a lot of that will have to do with an individual's specific needs. When that conversation between an employee and an employer, and in some instances, if the individual is a unionized employee, the union would also be involved in that conversation about accommodation. And also, if disability is the factor or the ground under which the accommodation is being requested, physicians may also be included in that conversation, well, at least should be, to be able to set out the limitations and restrictions. But the employer does have limits in terms of their duty to accommodate. So the employer has to accommodate up until the point of undue hardship. So if the employer or the employee's request for accommodation would cause undue hardship on the employer, then that is a defense and is a sort of eliminates their obligation to take certain steps. Undue hardship is a legal analysis and likely turns to whether it's cost or health and safety concerns or impact on the workplace generally. So if the employer says to accommodate the specific employee's needs, it will cost us too much and it is not viable for us to spend this money, that can be a defense for the employer to say we won't be able to accommodate your needs. Okay, this again, undue hardship is very employer specific. So you can imagine a smaller employer will have a lower threshold, whereas, for example, a government, costs, if they're claiming costs as an undue hardship, will be a much higher level and threshold to meet. So that's generally the principle of duty to accommodate. The next area that I would like to discuss are the different types of leave available to you as a caregiver. Now, there are leaves and then there are benefits. So I'll talk briefly about the types of leave and then we'll get into benefits. So there are a few different types of unpaid job protected leaves, both provincially and federally. Now, for Ontario employees, they are governed, or most employees are governed by the Employment Standards Act. The Employment Standards Act does allow for different types of leave for caregivers. One of those is the family medical leave. And this allows time for an employee to take off work. They have their job protected during that time for them to be able to provide care and support to certain family members in very sort of serious health condition and sort of significant risk of death. There is also the family caregiver leave, which is another job protected leave under the Employment Standards Act in Ontario. And this too is to allow an employee to care for a family member, but sometimes with less significant risk of death. Lastly, under the Act, there is the critical illness leave, which also provides employees a time frame to care and support a family member, okay, whose baseline state of health has changed significantly. So those are three types of leave that are protected under the Employment Standards Act that would be available to caregivers. Now, federally, for federally regulated employees, they have the compassionate care leave and a leave related to critical illness as well. For unionized employees, they may also have additional rights to leave depending on their collective agreement. And then for non-union employees, they may have things set out specifically in their employment agreement or employment contract, giving them rights to certain amounts of leave for these different criteria. In addition to leave, which would in most circumstances be an unpaid leave, but a job is protected during that time, employees may also have access to paid benefits. Now, these are not related to caregiver duties and responsibilities. These are linked to medical conditions. So if either related or unrelated to your caregiver duties, an employee is unable to work because of a medical condition, then they have access to different types of benefits, paid benefits. The first one being EI sickness benefits. So this is a short-term solution. Right now, the government is paying up to 26 weeks of EI sickness benefits, so employment insurance sickness benefits. And the idea behind these benefits is if an employee can demonstrate that because of a medical condition or injury that they are unable to work, then they can apply for and access these EI sickness benefits. At this time right now, the maximum is $695 per week. Like I said, up to 26 weeks. And so what employees tend to do is when they first are in discussion with their doctors, realize that they are unable to work because of medical conditions. They may use up their sick time available to them. And then if they've contributed enough in terms of EI, they can apply for EI sickness benefits. The application can be done online or on paper. And the employee has to demonstrate that they have a medical condition preventing them from working and that they've at least been employed for a certain amount of hours to access and be entitled to benefits. The next step, if an employee continues or remains unable to return to work because of a medical condition, some employees have access to both short-term and long-term disability benefits, either through their employment or if they've entered into an insurance policy privately or personally. Now, I would say majority of employers offer long-term disability benefits. Short-term are less popular or just less frequent. So most employees would use their EI sickness benefits, and then if they remain unable to work, they would apply for long-term disability benefits with an insurance company. So each insurance policy varies, but generally, the idea behind a long-term disability benefits is really an income replacement for employees who are unable to work because of their medical condition. Most definitions of disability include that for the first 2 years where you're off work because of your medical condition, that you have to demonstrate that you are unable to do your own occupation for those 2 first years. So that your medical symptoms, whether they be physical, mental, cognitive, prevent you from doing the essential duties of your own job. Okay? After those 2 years, the definition in most policies changes to any occupation, which means you have to demonstrate through medical information and documentation that your medical condition prevents you from doing any occupation. And then each policy will have their own specific language, but sometimes it's any occupation where you could earn 66% of your old salary, or any occupation for which you could reasonably be trained for. But the threshold becomes much harder to demonstrate after a 2-year period. And most LTD, long-term disability benefit policies, end at age 65. So after 65, you would not be entitled to any more disability benefits. Okay? For both short-term and long-term disability benefits, an employee has to apply for these. As soon as it becomes clear in conversation with a doctor that that employee can no longer perform the duties of their job or right at the beginning. And so it's really important to involve a medical professional early on in the process to ensure that you have the proper medical documentation to confirm that you meet the definition of disability as per your policy. In terms of applying, most often there are 2 statements or forms that need to be completed. One would be, or 3, apologies. One would be a form by your employer setting out what your duties were and what your job was. The second one would be a form that the employee would have to fill out, confirming what they've been going through, what the changes that they've been experiencing. And the third would be from a family or from an attending physician. So ideally a family physician, or if experts are involved, the expert as well could complete the form. And what I always recommend in these applications is to also, because the forms are quite limited in terms of what you can say or write down, is to include an additional form or separate document providing details as to why you, or let's say if you're assisting someone applying for LTD benefits, why that employee cannot perform the work. And so here it's sort of setting out, right, the day-to-day symptoms, the effects of those symptoms, the decreased ability to do day-to-day tasks, right? Describing what a normal day looks like, and in circumstances where maybe an employee might push themselves a little bit too much, what the impact would be on the following day, for example. And then describing why they can't work. So what symptom or what limitation and restriction prevents them from doing XYZ duty that that was part of their job before leaving on medical leave. Now, relationships with insurers is a very interesting one and comes up a lot when we have consultations with people, with employees who have applied for disability benefits. And my best advice is, like my advice with respect to duty to accommodate, is really to keep things in writing as much as possible, and to communicate truthfully and honestly, and to respond to the requests in a timely manner. So insurance companies are entitled to ask for more medical information or documentation, and the employee has to provide that for the insurer to properly assess their request for a claim for disability benefits. But it's important to remember that the insurance company is not there to be your friend, as much as they may be very friendly on the phone. It's very important to be careful in terms of what we share during those calls. And so what I see frequently happening is you get on a call with your case manager, they say, "How are you doing today?" Or to the employee applying, say, "I'm having a great day today. It's very sunny, I'm feeling great." And then they put that in their notes. And then the next thing you know, you get a letter saying, you know, you've confirmed that you're doing much better and things are going well. We don't think that you meet the definition of disability any further, right? So very important to be careful with the words that we're using with insurance companies, and making sure that things are backed up in terms of medical notes or reports. Okay. Now, the last benefit that I would like to discuss is the CPP disability benefit. And I've sort of gone through them in terms of sort of orders of application, right? And so initially, if an employee is no longer able to work because of a medical condition, they would use their sick leave, apply for EI sickness benefits if they don't have access to short-term disability benefits, then depending, maybe short-term and then long-term disability benefits. The last one that's available that tends to be that where employees tend to apply for is a bit later is the Canada Pension Plan disability benefits. And the reason for that is the threshold to access these benefits is quite higher than that of EI or short-term or long-term disability benefits. Because to apply for CPP disability, you have to demonstrate that you have a severe and prolonged disability. And so to demonstrate that, an employee tends to have to be off work for a certain amount of time to demonstrate the severity and the prolonged aspect of that disability, preventing them from working. Also, CPP disability is for employees under the age of 65. And they must meet certain contribution requirements in terms of how much they have contributed over the years into CPP. So severe and prolonged requires an employee to demonstrate that they are incapable of regularly pursuing any substantial gainful occupation. So not just their own, it's any occupation. And the prolonged aspect of that definition is that the illness is likely to be continued or for an indefinite duration, or is likely to result in death. Okay. Applications for CPP disability are done with Service Canada and need to be supported by medical evidence from doctors testifying that the disability is severe and prolonged. One element to be aware of is if an employee is applying to these various benefits. So in the event that an employee has applied for long-term disability and has been approved, and then applies for CPP disability, then and gets approved for that as well, CPP disability will likely, depending on your policy, be deducted from what you are getting from your LTD provider, right? So an LTD insurance provider is usually a payer of last resort. So they will deduct any other amounts that you receive and then pay you the difference. In some LTD policies, you will also find an obligation after a certain amount of months to apply for CPP disability. And if you don't, they will assume you would have gotten it and will start deducting a certain amount from your LTD. So important to make sure to review your policies, and if you have any questions, to consult with a lawyer specialized in that area to ensure that you're taking the appropriate steps. So just to finish off, and I guess we've gone through this a bit quicker than I thought, it is really the idea that there are, for employees who are still at work or who are unable to work because of these various factors that we discussed, there are certain types of leave, protected leaves, and benefits available to these employees, and also processes in place if an employee can continue to work to ensure that they can do so in a comfortable environment that allows them to be successful and productive employees. If at any time you or someone you know is faced with these challenges in the workplace, my biggest advice is always to consult as early as possible to be able to explore these options and discuss what is happening early on in the process, and to speak with someone who is knowledgeable in labor and employment to be able to properly advise you and recommend the best steps forward.